Hi, thanks for clicking on this video to learn more about the child welfare process with a specific focus on initial welfare involvement at the hotline and emergency response level, including timelines for reunification. We'll focus on placement and permanency in a separate video coming soon. I hope this info is helpful to you and will deepen your understanding of the child welfare issues faced by Linkages families as they navigate the system. One key thing I want to address up front is that California is a county administered child welfare system. That means things can look pretty different county to county. Each county is able to develop policy and practices in alignment with direction from the state, so their practices differ. I will be as general as possible to avoid big differences with county practice, but please understand that things may look slightly different in your county. I'll also try to point out areas of difference that I know about as we go through the process. Let's start with talking about why this matters for Linkages teams. Because your Linkages work involves families who are engaged with both CalWORKs and child welfare, the overlap creates both challenges and opportunities for collaboration. If we can understand each system better, we can help families navigate them more effectively and maybe even shorten the time families are involved with child welfare or prevent child welfare involvement altogether. We'll also touch on some important frameworks like California's Child Welfare Core Practice Model, Integrated Core Practice Model, and the broader system of care, all of which center the needs of children and families in a coordinated and trauma-informed way. Let's get started by taking a snapshot of child welfare in California. As of April 2025, there were about 38,264 children in foster care in California. And you can see from the table on the slide that this is the result of a decreasing trend over the past 10 years. That 10 years ago, almost 60,000 children were in care in California, and today that's under 40,000. This is due in part to prevention-focused strategies, community-based supports, and changes in how cases are handled at the front end. There's work going on right now to better understand this trend and do what we can to maintain this trend going forward. The majority of children enter the system due to neglect, and although poverty and housing instability are not considered neglect, these issues often contribute to the family challenges that make neglect more likely to happen. So what you can see on this table is the black line up at the top is showing the total number of children in foster care. The blue trend line underneath it is showing how many of those children had neglect as the primary reason for their entry into care. So you can see that neglect is much higher than any of the other forms of maltreatment, which are represented in the lines toward the bottom of the slide. Physical abuse being the most next commonly occurring reason, but it is way below the line for neglect. Other contributing factors for neglect include parental substance use, domestic violence, and mental health challenges, all of which are issues that CalWORKs Welfare to Work workers are familiar with and can help child welfare address. A key thing to talk about as we talk about child welfare is the significant disproportionality that we see among children in care. Systemic inequality is a contributing factor for child welfare involvement. And what this slide is showing you is how much more likely children of color and Native American children are to have foster care entry in their lives. So the line in the middle represents the likelihood of a white child entering foster care. So you can see that this line represents the increased likelihood of African American children entering care. This line represents the increased likelihood of Latino children entering foster care. And this line represents the increased likelihood of Native American children to enter foster care. We also see that Asian and Pacific Islander children are significantly less likely than all the other categories to enter care. We're concerned about all of these disparities and continue to seek to understand why these disparities occur, how we can address them, and how we can make sure that children are safe. So let's talk a little bit about how families get involved with the child welfare system. Every county has a child welfare hotline staffed 24 hours a day with social workers who take calls and make decisions about how the child welfare agency will respond. Most calls come from mandated reporters like teachers, doctors, or police officers, but anyone can make a call to the hotline if they're concerned about a child. Reports can also be made in writing. Counties use tools like structured decision making, also known as SDM, and red teams to help hotline workers decide how the agency will respond to each call that they receive. A red team is a multidisciplinary group that reviews, evaluates, and directs responses to referrals about child maltreatment. And it's important to know that there are several different things that can happen after the child welfare agency receives a call. The key question that's answered at the hotline is, should this referral be evaluated out, which would mean there may be a referral to community-based services, or the referral could just be documented in the statewide database with no further action taken by the child welfare agency. The other option is an investigation or an in-person response. One of the key things that red teams do is to support a group decision-making process that may reduce bias. As we saw in the last slide, there is significant disproportionality in the families who are involved with child welfare based on race and ethnicity. Um, and data show that this disproportionality starts at the hotline. So we receive more hotline calls on Black or African American children or Native American children. And those families are also more likely to be screened in for an in-person response. Things like mandated reporter reform and red teams are key ways that child welfare is trying to address this disproportionality at the very beginning of cases to stop it before it even gets started and make the system more fair and equitable for families of color. So let's talk a little bit about what happens during an investigation. If a referral is screened in for an in-person response, there are a few key timeframes to follow, and they are fast. The initial contact timeline is determined by the circumstances of the referral. The child welfare worker will either need to make contact with the victim children within 24 hours of the report or within 10 days of the report. 24-hour or immediate response referrals are usually related to physical abuse, sexual abuse, or severe neglect situations in which there are concerns about the child's immediate safety. There may also be an immediate response referral if there are concerns about losing contact with the family if we wait, or because police are requesting an immediate response. Note, there are other timelines in some counties that are faster than what the state requires. So a 2-hour response, a 3-day response, etc. But the 24-hour or 10-day responses are the state requirements. Now, once the social worker has gone out and made contact with any of the victim children identified in the referral disposition timeline starts. And that means the child welfare worker then has to complete all the contacts and assessments needed and close the referral within 30 days of that first face-to-face contact. The worker is required to see all parents and children in the household. They may also need to complete collateral contacts with the child's doctor, school, other service providers, or others who have information about the family. They may also need to hold a child and family team meeting or CFT and develop a safety plan with the family. If the family has a welfare to work worker, that worker may be able to offer additional services to prevent opening a child welfare case. And it's great practice to include the welfare to work worker at the CFT. Finally, let's talk about the court timeline. Detention hearing and petition filing happen very quickly if a child has to be placed in out-of-home care to protect the rights of the child and the parent. So if a child is removed from home, the agency must file a petition within 2 days of removal and must notify the parents and the tribe of a detention hearing to be held the next day, the next court day. So 3 days from the removal date. At the detention hearing, the court will decide if the child will remain in foster care temporarily until the next hearing and may order some type of visitation to occur between the child, siblings, and parents. This period of referral investigation is a fast but structured process to assess strengths, needs, safety, and potential risks leading to decisions about the referral outcome. The ER worker must also decide 3 key things during this period. Is the child in immediate danger that can only be addressed by removal from the home? The structured decision-making safety assessment tool helps the child welfare worker identify threats to the child's immediate safety. If there are safety threats, the worker will work with the family and the family's team to develop a safety plan. If no safety plan can be developed to address the safety threats, the child will be removed temporarily and placed in foster care. We'll talk more about that placement in part 2. The emergency response worker must also determine if the allegations are substantiated, which means that they are true, inconclusive, which means that we are unable to determine, or unfounded, which means they are not true. Even if the children can remain safely at home, the child welfare worker also has to determine what level of ongoing interaction may be needed with the child welfare agency to address safety and risk concerns. The structured decision-making risk assessment tool helps the worker identify the risk level for the family, and typically families with a high or very high risk score will have a case open for ongoing work with the agency. After the investigation, there are several possible outcomes. The first is that a referral may be closed with no further intervention from the agency. This may happen because the family refuses referrals to community agencies. The referral was historical or the referral was completely untrue. The next option is that the referral would be closed, but there would be a connection made to community resources. This involves connecting the family to community-based services, and in some counties, this is called differential response. This is where CalWORK supports could make a difference for a family to help them avoid ongoing involvement with the child welfare agency if there are services available to the family through CalWORK's Welfare to Work. And then the final and least common option is opening a case. This option allows the child welfare agency to provide services and work with the family to resolve concerns or find alternative permanent plans for the child. This can involve a court process or could be a non-court or voluntary case. As noted, decisions are guided by the SDM tools, which help the child welfare worker assess immediate safety concerns and risk of future maltreatment. Only a small percentage of referrals lead to court involvement or removal, but these are life-changing decisions. So the child welfare workers try very hard to avoid unnecessary involvement with the agency. We know that child maltreatment is a traumatic event for any child, but we are also aware that system involvement brings additional challenges. I want to pause and take a moment to talk about and honor the issue of tribal sovereignty and child welfare. Historically, the child welfare system did not honor tribal sovereignty or tribal culture when working with Native American families. Many Native American children were removed from their families and placed outside their tribe with no effort to maintain their connection to tribe and culture. As a result, the Indian Child Welfare Act, also known as ICWA, was passed to prescribe specific activities and preferences that must be followed if the family or child is a member of a tribe or may be eligible for membership. Social workers must ask all involved parents and family members about Native ancestry as early as possible in the referral process and over again as the case progresses and new family members come to light. If the family is affiliated with a tribe, the agency must notify the tribe and engage with the tribe to preserve connection with the tribe. Um, this includes involving tribes in the court process, where the tribe will be recognized as a party to the case and will be included in making placement and permanency decisions with the family. This is another area where practice may look very different in your county. Some counties work with tribal social service agencies or have specific arrangements or agreements with local tribes. Other counties do not have those same relationships, but all counties must follow the letter and spirit of ICWA. It is not optional, it is federal law, and it's critical for preserving tribal identity, culture, and sovereignty. Let's talk about the different kinds of child welfare cases. If a safety threat exists that cannot be resolved with a safety plan, or if there's a substantiated allegation and high or very high risk, a case may be opened. This can happen with court involvement or through non-court or voluntary services. Whether the case goes to court depends on risk level and safety factors, all evaluated through SDM tools and in consultation with the family and their team. Whether and when to have a non-court family maintenance case with a family varies greatly from county to county, so your county practice may look very different. One key thing that CalWORK staff may have noticed, when the case transfers from referral to a case, most counties assign a new child welfare worker to work with the family through that initial court process. Emergency response workers typically specialize in working with the families through the referral process until they close the referral, either by closing it out or opening a new case. And at that point, the family is transferred to another worker. This could be a court worker or dependency investigation worker, or it could be a non-court family maintenance worker, voluntary worker, or family preservation worker. And this usually happens at around the 30-day mark if the child has not been placed in foster care. This can get confusing as you may need to identify the new worker to maintain your connection with the case. If the family will be involved in a court process, typically the court worker or dependency investigations worker will work with them through the initial court hearings to establish the jurisdiction of the juvenile court and determine the case disposition or case plan for family maintenance or family reunification. If the family will have a non-court case, they will transition to a non-court or voluntary worker. That worker will usually stick with the family through the duration of the case, which could be 6 to 12 months. I also listed on the slide another planned permanent living arrangement, also known as APLA. And that's the type of child welfare case that happens when a child has gone through a court process for reunification and was not able to reunify and does not currently have another permanency option such as guardianship or adoption. We'll talk a little bit more about that type of child welfare case in the next video. I want to go through the court timelines because they can be fast and they can be confusing. And at the end of this initial court process, there will be another case transferred to the ongoing worker. So if the situation leads to court, things move quickly. If a child is taken into temporary custody, a petition must be filed within 48 hours of the child's detention, excluding non-court days. The detention hearing then must be held by the court the next judicial business day from the date the petition is filed. So if the petition was filed on a Friday, the detention hearing would be on a Monday. During such a hearing, the court determines whether the child will remain in placement. Typically, at detention hearings, the parents, the agency, and the child are all represented by their own lawyers. If a tribe is involved, the tribe may also have legal representation. All these parties contribute their opinions and information about the situation. The agency typically also prepares a written report called a detention report, outlining why they believe the child cannot safely remain at home. Following the detention hearing, A jurisdictional hearing should be set within 15 days. The juris hearing allows the court to make findings on the allegations in the petition, and if they are true, the court may take jurisdiction over the child. This allows the court to make certain decisions on behalf of the child and in the child's best interests. Welfare and Institution Code Section 300 describes the circumstances under which the court may take jurisdiction over a child. This section lists the types of maltreatment that result in court intervention, including physical abuse, neglect, sexual abuse, emotional abuse, cruelty, or abuse of a sibling. The child welfare worker also submits a written report for this hearing, and many times the family will contest the jurisdiction, resulting in a mediation or a trial or contest with witnesses. The third type of hearing a family will have is the dispositional hearing. And sometimes this can be combined with jurisdiction for something called juris dispo. The dispositional hearing answers a specific question about what will be in the family's case plan and whether the family will receive family reunification or family maintenance services. The court orders a case plan for the family outlining their goals and associated services that the court believes will help the family resolve the concerns and meet their goals. The child welfare worker also submits a written report for this hearing, and this hearing may also be contested and resolved with mediation or a trial. It's important to note that the case plan that the court reviews comes from the child welfare agency and should be developed together with the family, and the linkages worker could also be involved in the development of this case plan. The court, however, may make changes to the case plan at the time they order it. Following the dispositional finding, the family typically gets a family maintenance or a family reunification case plan ordered with a follow-up court date in 3 to 6 months for a status review. At this point, in many counties, the case is transferred to the ongoing worker who will work with the family through the family maintenance or family reunification process. I want to mention 3 key issues for child welfare that may not be known to our CalWORKS partners: bypass cases, paternity status, and concurrent planning. Regarding bypass cases, in some situations, the family will not receive reunification services even though their child was removed. This happens in situations where there are serious concerns about the parent's ability to safely reunify based on Welfare and Institutions Code Section 361.5b. This law includes several specific situations that require the agency to consider not recommending reunification services. The agency may still recommend reunification if they believe it's in the best interest of the child, and the court may order reunification even if the agency recommends bypassing reunification services. Reasons to recommend bypassing reunification services include serious physical or sexual abuse of the child or siblings, chronic substance abuse with prior failed reunification, prior termination of parental rights, felony convictions involving violence or child abuse, failure to treat mental illness, refusal or failure to reunify previously, serious domestic violence, abandonment, or conviction of killing another child or the child's other parent. If the agency recommends bypassing reunification services, they must have an alternate plan for permanence in place. This may include adoption or guardianship. And next, a note about fathers. If a family's case goes to court, the child welfare worker must work with the family to determine the paternity status of the father in relationship to the child, as the paternity status impacts what the court may order for him. There are 3 main options. The first is the alleged father status. This refers to a person who may be the biological father, but whose paternity has not been legally established. Alleged fathers have very limited rights and are not entitled to reunification services. They must establish paternity via DNA declaration or court action to elevate their status and gain legal rights. The presumed father is the second status. This refers to a father who has legal status within the case based on the following criteria: being married to the mother at the time of the child's birth, or living with a child and openly expressing a paternal relationship to the child. Signing a voluntary declaration of paternity or VDOP is another way to become a presumed father. Presumed fathers have full legal rights, including custody consideration and reunification services. Finally, there is a status called biological father. This refers to the child's genetic parent based on DNA testing. Biological fathers are not automatically granted custody or reunification services. They must also qualify as a presumed father to get full rights in dependency proceedings. An important distinction to make is that biology does not confer parental rights. If there is a presumed father and a biological father, the court may find the presumed father has a right to reunification services and the biological father does not. Finally, I want to mention concurrent planning. Concurrent planning is the concept that child welfare social workers may be working toward multiple goals at once. While reunification is always our primary goal for families receiving family reunification services, we must also be working at the same time on a backup plan for permanency in case the parents cannot reunify. That's called concurrent planning, and it's why even during the FR period, we would be talking to relatives or other caregivers about permanency options such as adoption or guardianship. Best practice is to include the child and family team in this backup planning, but this process can be emotionally complex. Let's talk about the family reunification timeline. Once reunification is ordered, the family has 12 to 18 months to complete their case plan in most cases. Extensions to 24 months are rare and are only granted when reunification is likely and the child is over age 5. For children under age 5 or children in a sibling group with children under age 5, the maximum reunification time is 18 months. During the reunification period, the family will be working on their case plan to address the concerns that brought them to the attention of the Child Welfare Agency. During this time, families follow a case plan with clear goals and services. Social workers use tools like the reunification assessment, child and family team meetings support planning and progress, and children receive services based on their CANS assessment. Visitation happens, usually starting as supervised visits and progressing as safety allows to a 30-day trial visit home before reunification is ordered. Working with the family over the course of their case plan is a collaborative process. The child welfare worker helps to center the family in a team comprised of natural supports, service providers, and other supports following the values and principles outlined in the Integrated Core Practice Model, or ICPM. This model defines how we work across disciplines to help families. The Linkages partnership is a key part of this collaborative approach and can help family focus on the key activities they need to focus on to build safety and improve their circumstances. When determining whether or not to recommend reunification, the child welfare worker works with the family and their team to assess ongoing risk of future maltreatment, the safety of the home, and whether or not the family can meet the minimum sufficient level of care to keep the child safe. This assessment does not require the parents to be perfect or to fully address all of their challenges. It means that the family has a solid support network and can keep the child safe and meet the child's basic needs. It's important for child welfare workers to not hold families to an unrealistic standard when considering reunification. That brings us to the end of part 1. So we've covered how families enter the system, how investigations are handled, and what happens when a case is open. We've also seen the critical role of timelines, tools, and team-based planning. In the next section, we'll dive deeper into placement types, permanency options, and how permanency decisions are made. Thank you, and let's continue building our shared understanding so we can better support the families we serve.